At Denton Peterson, we represent a lot of clients who are out of state, that is not in Arizona, who are involved in litigation in Arizona for whatever reason. It's important to understand exactly what the default rules are as you decide how to move forward if you're going to be involved in litigation in Arizona. There's two different court levels in Arizona. The first is Superior Court. The second is Federal Court, or District Court as we call it. And the rules are very different for each, so it's important to know the difference. If you've been sued in state court, that is Superior Court or Justice Court, the rule is that if you were served outside of Arizona, you've got 30 days to file your answer or your responsive pleading. Those are calendar days, not judicial days, so it's 30 days as you count on the calendar. In order to get a default against a defendant in state court, a plaintiff must file a notice of default, and then they have to wait 10 judicial days, that's usually 14 calendar days, before they can then get the default judgment. So in the case of a case that was filed in Maricopa County Superior Court or in Justice Court, there's usually that little warning shot, a notice of default, so to speak, where you know that, hey, there's a serious risk here of a default judgment. Federal court's a little bit different. If you're sued in federal court, regardless of where you are when you're served, you have 21 days to file your answer. And there's no 10-day warning shot in terms of a notice of default. Once that 21 days runs, the plaintiff can file default paperwork at any time, and the defendant thereafter is at risk of getting a default judgment entered against them. You have to be, frankly, a little more careful if it's a federal case about not missing that default deadline. Either way, it's common for lawyers involved to get extensions. We represent a lot of defendants, people who've been sued in Arizona who are outside Arizona, and it's very common for us to call plaintiff's counsel and arrange for extensions that are necessary if we've got logistical issues or just need a little bit more time to get our responsive pleading filed. It's important to talk to a lawyer to prepare about these things a little bit in advance of when things are going to be due. You don't want to call your lawyer 24 hours before that default deadline is about to run, because you want to be able to prepare carefully. You may want to file an answer, or it may be that you're filing some kind of a motion to dismiss. You may want to file a counterclaim along with the answer, or maybe not. It just depends on what your particular situation is, and you really need some careful advice from an experienced lawyer in order to be able to do that. You may even have affirmative defenses. You may have, for example, a defense of statute of limitations. It's been too long since the events happened for the lawsuit to be filed. Or you may have a claim that there was duress, that there was a contract entered, but there was actually duress involved in it, or something like that. Whatever the response is going to be, it's absolutely essential to make sure that you discuss it in detail with your lawyer before you get that responsive pleading filed.